Okay, welcome everybody. I'm Professor Ed Lee. I'm the director of IP program. It gives me great pleasure to kick off our BookIT talk series. It's a series for authors of recently published books in IP, privacy, and law and technology. And today I'm welcoming to Chicago, Kent for her first visit, it's hard to believe, Professor Sharon Sandeen, who has published a book that is coming out.
It's out now in the UK. Right?
It's out in the UK. In the United States, it'll be out
any day now.
Any day now. So you're getting the first book talk of her about her book, Trade Secrecy and International Transactions, Law and Practice, co-authored with Elizabeth Rowe and published by Elgar. And you can find handouts about the book. If you haven't picked one up, feel free to pick one up on the way out. I'll just give a brief introduction to Professor Sandeen. She graduated from the University of California, Berkeley, getting a BA there as well as later an LLM. In between, she received her JD from the University of the Pacific, McGeorge in California. She practiced for numerous years as an IP and business litigator in Sacramento. And she also has remained active in the bar. She served as, for instance, the chair of the IP committee of the business law section of the American Bar Association. And she's currently in town for an ABA meeting as well. And she is known internationally as a trade secret expert. This is her third book related to trade secrets. So it gives me great pleasure to turn it over to Professor Sandeen.
Thank you very much. Now, is this on? Do I need to use this or?
Yeah, we can turn it on.
Okay, might be helpful.
Is that a red button?
Mm-hmm. Is there a knob or something there?
Turn it off.
Great. Well, thank you very much. And I want to thank Professor Lee for inviting me. This is my first visit to Chicago, Kent, but what I always like to say is that my roots are in Chicago. Both my grandmother and my father were born in Chicago. In fact, my grandmother was born not too far from here, in the parking lot that now exists across the street from the Whole House. She was an Italian immigrant, and so she lived in that neighborhood, known as Little Italy. I'm very happy to be here to talk about the new book that I wrote with Elizabeth Rowe, and you can see the cover on the screen here, Trade Secrecy and International Transactions. My plan is to, of course, talk about the book, but I also will discuss some of the issues it raises and that I predict will need to be resolved in the future. And I don't know how many of you in the audience are interested in trade secret law in the future, but it is an area that needs more scholarship and more study. And so if you have an interest in it, I'd encourage you to get involved. Now, one of the things that's going on is there's a lot of attention being paid to trade secrets for a reason I will discuss in just a moment. But I'm going to start first with explaining the structure of the book, and then I will talk about where we were, where we are, and where we are going. And if, would it be appropriate, Ed, to entertain questions while I talk, or should I wait till the end?
Probably wait till the end.
Okay, okay, great. Okay, so the book is actually organized into two parts. The first part is an overview of trade secret law based on the WTO TRIPS agreement provisions, which are Article 39, and then also based on the fundamentals of U.S. law. Now, the reason why I focus on U.S. law, we focus on U.S. law, is because that has been cited as the gold standard, if you will, trade secret law, and it also was the basis of for the language that is contained in Article 39 of the TRIPS agreement. Also in part one, however, we wanted to make this book because it's part of the publisher's Law and Practice series. We wanted to make it, very usable by attorneys who are trying to protect trade secrets internationally. And so it has two parts to that. One is the business-to-business relationships and how you protect trade secrets in those relationships. And the second is employment relationships. Now, although at a high level we tend to lump all trade secret issues together, there are important practical and policy differences arising from these different contexts, which I will mention as I go forward. The second part of the book looks at the trade secret principles of 7 different countries, some that follow the common law tradition and some that follow the civil law tradition. For those of you who take Professor Lee's International IP course, are familiar with international law, these concepts of the difference between common law and civil law and so forth are probably well known to you. But we thought it was important to really explain that, and particularly for U.S. lawyers who may not be familiar with kind of, civil law systems and how the sources of law are just different. So we went into quite a bit of detail, just trying to fill gaps in what we anticipate some people's knowledge would be about the different types of legal systems in the world. The countries we picked are shown on the screen, and there's a reason for them. We picked the United Kingdom because trade secret law really originated in the United Kingdom. We picked Mexico and Canada, of course, because they are parties with the United States in the North American Free Trade Agreement, which was the first major agreement to include a trade secret provision, followed then by the TRIPS agreement. We included the so-called BRICS countries, except we left Russia out, so that accounts for Brazil, India, and China. Now together, I think reading the part 2, although it deals with specific countries, it gives a glimpse of what happens in both common law and civil law countries that we hope will be translatable to attorneys trying to figure out the laws in other countries. Okay. Okay, so let me move on and talk about where we were, a brief history of trade secret law. It really developed in the 19th century due to the Industrial Revolution, or I have in parentheses revolutions. Sometimes people talk about multiple industrial revolutions, both in England and the United States. But the basic point of tying trade secret law to that, and Professor Catherine Fisk at UC Irvine has written a book on this and several articles, is that once we started to have more mobility in employment and more sharing of information, trade secret disputes started to arise, and so that's why it started in the 19th century. And so in the United States, it came over from England, and so trade secret law has traditionally been based upon common law. And importantly, it's been based upon the common law of unfair competition. As intellectual property rights go, trade secrets are relatively new, only really being labeled as a form of intellectual property in the last 25 years or so. And in fact, in the history of trade secret law, there was a really big debate about, are they property or are they unfair competition? That debate rages today, and there are people that want trade secrets to be viewed in more absolute terms as property, and others that point out that no, it is a form of unfair competition. Now, the history of trade secret law as coming out of common law and unfair competition is important to understand as one looks beyond U.S. boundaries, because many other countries have a similar history, particularly, as I mentioned before, citing the UK and Canada. Any country that had former ties to England and that still maintains the common law tradition tends to have trade secret law that is similar to what exists today in the UK. Basically, that law in those countries is referred to as a law of confidentiality. And within that law of confidentiality in the UK, New Zealand, Australia, Canada, etc., there's actually two parts. There's the personal information privacy part, and then there's the business confidentiality part. And that's the part that obviously involves trade secrets. Now, given this history of the common law development of principles of unfair competition, it is also important to recognize that although there may be a common origin for trade secret principles, the common law process that was followed and is followed by each of these countries means that there have been some divergences in some particulars. It also means that what constitutes unfair competition is left to be determined by the values and mores of a particular country. And interestingly, in the United States, it means that what trade secret law means in actual application is dependent upon the views of each individual state. Now, some basics, as the last screen pointed out, in 1979, the National Conference of Commissioners of Uniform State Laws, known as NACUSL, which is based right here in Chicago, but now known as the Uniform Law Commission, adopted the Uniform Trade Secret Act, and then it has subsequently been adopted by 47 of the 50 states, the U.S. Virgin Islands, and Puerto Rico. The only outlier states are New York and Massachusetts. North Carolina has not adopted the UTSA, but it has a statute that's somewhat similar to it. So essentially, and this, what I put up on the screen here is true about U.S. trade secret law, and it's essentially true about all trade secret law in the world, particularly with respect to WTO member countries who have to comply with Article 39. Because at least these two aspects of trade secrecy are defined in Article 39. The first is that you have to have the existence of one or more trade secrets, and the second is that you have to have an act of misappropriation. Now, from the early days of the development of trade secret law, it was clear that it was intended to protect secret business information. However, over time, and this is very important, the law of trade secrecy evolved so that it became clear, or I would say clearer, that it does not protect all secret business information. So trade secret law does not protect all business information, and it doesn't even protect all secret business information. It only protects information that satisfies three requirements, and they're up on the board: secrecy, independent economic value, and reasonable efforts. Now, those three features can be found in a lot of countries' laws with a little bit different terminology, but they're essentially the same because it's what's in Article 39 of the TRIPS agreement. Now, there are important reasons for these limitations. Going forward, as we think about how broad or narrow trade secret law should be, we have to think about why there's any sort of definition or limitation. One reason has to do with the public's interest in the free flow of information. The broader trade secret protection is, the less there's a free flow of information. Second are general tort principles that generally require harm. So this is where the independent economic value comes in. You have to prove that you have information that actually has some value and that you would be harmed by losing. A third concern is the channeling function that the limitations perform. And in the United States, there's a famous U.S. Supreme Court case called Kiwani, in which the U.S. Supreme Court basically said, you know, we're going to let state trade secret law exist, but it can't be so strong that it's going to interfere too much with patent protection. So the idea is our policy in the United States is we want people to get patent protection if they can and not use trade secrecy. So one way to do that is to make trade secrecy relatively weak so that people will be encouraged to seek patents instead of trade secrets. Another reason for the limitations there are evidentiary considerations. Since trade secrets are secret, we need some way to verify that they actually exist. And the way to do that is through these three requirements. Finally, there is a notice function, which is very important, particularly in the employment context. If we're going to hold employees responsible for trade secret misappropriation and potentially put people in jail, it's a federal crime to misappropriate trade secrets in the United States, then there must be some way that they know what is a trade secret. And so these three requirements do that. The second requirement is a wrongful act of misappropriation. Originally, and significantly even today, in some countries misappropriation was defined as the wrongful disclosure or use of trade secrets. And this is true in the countries, including the UK, where it's the breach of confidentiality is basically the tort. Traditionally, defendants in trade secret cases were the people that were actually given the trade secrets by the trade secret owners and then misused them after being given them voluntarily. The idea of wrongful acquisition of trade secrets through some improper means is a relatively newer concept. And this is one of the issues that in the harmonization efforts we're trying to address, is to basically get countries to agree that it's not only wrong to wrongfully disclose and use, but also to wrongfully acquire. Now, related to all forms of misappropriation is a very important problem that trade secret law in the United States tried to solve, and that is also the focus of harmonization efforts. And that is how to impose liability on third parties who come to possess trade secrets. When you think about it, and Professor Robert Bone at University of Texas did in a very important article about 20 years ago, a lot of the problems surrounding secret information can be solved by self-help and by contract law. And this is something that makes trade secrets unique vis-a-vis other forms of IP. You can, as a business, protect your trade secrets simply by not sharing them or locking them down. But the problem is, if we only wanted to solve trade secret issues through self-help or contract law, the principle of privity of contract would not help us if those trade secrets ended up in the hands of a third party. So the way that was solved under the UTSA and is being solved in other countries is by imposing liability on third parties who come to possess misappropriated trade secrets if they knew or had reason to know they were misappropriated. And so I will mention that, the consequences of that a little bit later when I get to talking about current harmonization efforts, or future efforts. So I'll talk about current harmonization efforts now. So generally speaking, because trade secrets came out of common law and concepts of unfair competition, for many, many years we just allowed each country that might think that type of behavior was wrong to develop their own laws and rules. And there was no international effort to harmonize trade secret law or confidentiality law in any way. The first effort to kind of figure out what trade secret law was really happened in the United States, first in the Restatement First of Torts, 1939, that had provisions on trade secrets, and then later in 1979, the UTSA. But it wasn't until NAFTA it was enforced in '94, and then later TRIPS, where there was actually a multilateral, bilateral or multilateral or trilateral agreement that specifically mentioned trade secrets. And I have to say, I wrote an article on the history of Article 39 of TRIPS, and it was getting that provision into TRIPS was very difficult. It was a fought tooth and nail to the very end. And one reason why it finally got in, interestingly, is the U.S. negotiators were characterizing trade secrets as a form of property, and that didn't resonate with the rest of the world. And finally, I think it was Switzerland or some other country said, well, why don't we just call it unfair competition and cite back to the provisions of the Paris Convention, which talk about preventing unfair competition, then it will be settled. And so by labeling it unfair competition, they were able to get it in the TRIPS agreement. Now, a lot has changed in the last few years. When I first started practicing, most of the work in this area was being done by practicing lawyers. In the last 10 to 15 years, more legal scholars are paying attention to it. But something remarkable happened in the last 4 years. All of a sudden, government officials started to pay attention to it. And it was even mentioned in the President's State of the Union address this year. So I was really happy about that. Trade secrets were mentioned and patents weren't. But I think it's important to think about why this has occurred, because the reasons may explain what happens to trade secret law in the future. So two thoughts come immediately to mind. Maybe there is more interest in trade secret law and policy because trade secrets have become more important to businesses, particularly businesses that are operating offshore. Or maybe they are simply there are simply more threats posed by spies and cyber hackers that require better laws and enforcement. But I think there are other reasons as well. Perhaps the rhetoric of trade secret misappropriation in the United States is being used as a justification for ratcheting up protection for trade secrets and other IP laws in other countries. Or more problematically, at least to me, perhaps the fear of misappropriation is being used to upset the current balance of trade secret protection in favor of putative trade secrets owners. And I say putative because a lot of trade secret owners, at least statistically in the United States, don't win their cases because they can't prove the existence of the trade secret. What often happens in trade secret cases is somebody goes to work at a company, works there for years, the company's very dependent on that person. The person has a great new idea, decides to start their own business, starts their own business, starts competing, and the employers at the old company go to their attorney and say, this great employee just left, do something about it. And it's at that point the company finally figures out, oh, maybe I have trade secrets, maybe I have a trade secret claim, even though they did very little to protect their trade secrets before that. That's why a lot of companies lose in trade secret litigation. Now, to paint an even more nefarious picture, perhaps the increased talk of cyber espionage and trade secret theft has to do with the fact that some U.S. companies have figured out that IP rights are a great way to limit competition, and they want more of them. So in my international IP course, I, ask my students to consider whether in an environment where we're touting the benefits of free trade, intellectual property rights are actually used as the principal means now to limit free trade. Maybe there are ancillary political motives, such as advocating for the increased trade secret protection in order to get something in return. You know, so a lot of times in trade secret, increased trade secret protection is involved now in the Trans-Pacific Partnership Agreement and the Transatlantic Investment something. But anyway, it might be that they're pushing for higher trade secret protection to get it to trade off for something else, or maybe to give it up to get something else. There might be a political reason. Another reason might be, however, is that there's a move afoot both in Europe and in the United States to include a new remedy in trade secret law called the civil seizure order, which would allow trade secret owners to go in ex parte to the judge, get an order to seize trade secrets. That's a feature of the proposed federal legislation, and it's also a feature of the proposed EU trade secret directive. Now, whatever the reasons, I think we have to, as students of trade secrecy, as scholars, as lawyers, we have to pay attention to what's going on. Now, there's certainly benefits to harmonization. You know, at least in theory, greater protection for trade secrets will incentivize people to invent. There will be less acts of unfair competition. If there's more uniformity, there's more predictability, and businesses generally like predictability. Also, and this is kind of counterintuitive, but trade secret law is said to solve Arrow's information paradox, which is if people have, generally speaking, if people have secrets, they can only have value if they can use them and share them. And so trade secret law provides a context in which people who have information might be more willing to share that information with others, but in the context of a confidential relationship. So actually, in a weird, counterintuitive way, trade secret law is said to actually facilitate the sharing of information. And it also, in a weird way, facilitates the transfer of technology and the public dissemination of information, because trade secret law is weak on purpose, trade secrets will leak out. I know that sounds weird, but that's exactly what the U.S. Supreme Court said in Kiwani, is that because trade secrets are weak, trade secrets will leak out, and that is a benefit to society. The last benefit is less transaction costs. If we have trade secret theory or trade secret doctrine that allows trade secrecy to exist in the context of a confidential relationship where the parties don't have to enter into an express contract, then the parties don't have to negotiate an express contract, which lowers their transaction costs. So that brings me to where we are going and important issues going forward. So let me go through the list quickly, and then if there are any questions, I'd be happy to elaborate. One issue I already mentioned is the patent trade secret divide, where do we really want strong trade secret protection, because won't that prevent people from applying for patents? And that was a concern that the U.S. Supreme Court stated in Kiwani. There's two answers to that. One is a lot of information that is protected by trade secrecy, such as customer lists and financial information, would not be patentable anyway. So there's not that patent trade secret divide. But with respect to anything that might be patentable, which in trade secret lingo is called technical trade secrets, this is an important issue. In the United States, we address it because of our system of federalism, where we care about states being able to legislate in certain areas and not having the federal government interfere too much. In other countries, that's not the case. So there needs to be a more explicit understanding that if you increase trade secret protection, it might discourage patent protection. And I saw some of this in the EU database directive materials, that there's some sensitivity to that issue. Another issue is the definition of a confidential relationship. And this comes up, in our research on some countries' laws, the way this comes up is some countries, when they say, when they recognize that you have to have a confidential relationship in order to, before you share trade secrets, some countries seem to require an express contract, whereas the United States law would allow not only an implied contract, not only an implied in fact contract, but an implied at law contract. So how a confidential relationship is formed is one way the laws of the different countries may differ, but it's also a point of controversy concerning trade secret policy going forward. There's concerns about restraint of trade and enforceability of non-compete agreements. This is kind of an ancillary issue related to trade secrecy, but it's very closely related. The concern is that trade secrets and trade secret rights are being used to limit the ability of employees to move about the workforce. And I'm a native Californian, and California has a very strong policy dating from the 1860s that non-compete agreements are void, ab initio, unenforceable, and they're not even enforceable for the purpose of protecting trade secrets. Other states in the United States don't follow that. Other states say, non-compete agreements are presumptively enforceable, and they're particularly enforceable to protect trade secrets. So what you see internationally is you see some countries like Japan following more of the California model, and other countries following more of the allowing the non-compete. But that is a big issue going forward, and it needs to be thought through. What's interesting about the research in Japan was if you go back in time, after the war, the United States government basically told Japan, thou shall adopt laws, and these are the laws that you shall adopt. And the laws they adopted were much more pro-employee and pro-labor than what U.S. law has evolved into in 2015. In other words, what we thought was important in the 1950s, what the United States is different now, but it was embedded into the Japanese Constitution. And so the rights of employees in Japan is very strong, and that continues to be an issue. Related to that is the ownership rules. Some states in in the United States, California and Minnesota in particular, have laws that limit what an invention assignment agreement can do and what it can say. Invention assignment agreements are used by employers to end up owning inventions. What's interesting, in other countries, they even go further. Like in Japan, you can have an invention assignment agreement. It needs to meet certain requirements. But even though the invention ends up being owned by the employer, under Japanese law and also the law of the UK, the employee, if that invention ends up making a lot of money, that employee ends up is entitled to get part of that money. And U.S. companies don't like that, but that's been Japanese policy for a long time, so that's an issue. What constitutes reasonable efforts to maintain secrecy is an issue. Some countries, and I'll use Japan again, are much more particular in requiring proof of that. Whereas in the United States, I'll tell you from my research, if the behavior of the defendant is really bad, courts tend to overlook the failure of the trade secret owner to really do anything to protect their stuff. In Japan, you have to prove that you've engaged in reasonable efforts. And this is a point of contention internationally because because it's different from U.S. law, and U.S. companies don't want to do that. So that's an issue. What constitutes improper behavior is also a problem. In the United States, it could be criminal behavior is improper, tortious behavior is improper, and something else is improper. Just unfair behavior could be improper. In other countries, no, it has to be either criminal or tortious to constitute improper acquisition. So that's an issue going forward. And then finally, I added this because it occurred to me recently that because the acquisition prong of wrongdoing is relatively new, we really haven't thought it through. And what happens is, in a lot of cases, the defendant will misappropriate the trade secret, but the plaintiff acts quickly and gets an injunction. The trade secret is turned over. The trade secret, there's never a disclosure, and there's never a use. So from a traditional tort point of view, there's no harm because the trade secret was not used and it was not disclosed and therefore not lost. And so what we haven't really figured out is should a plaintiff in that case get monetary damages just for the wrongful acquisition, or should it only be injunctive relief? And we haven't really addressed that in trade secret law, and we haven't really reconciled it. So with that, I will open up to questions. I would be happy also to talk about the new federal legislation. Well, it's not new. It was introduced in late July, and it probably will be considered by Congress in the next month or so. Thank you.
Questions? Yes, back there, sir.
Yeah, I'm particularly interested in what kind of protections are there for like small startup companies that work at, let's say, Google, and Google sues that company or sues that startup and says, you created this idea, next Google or whatever, on company materials, company property. So basically, it hinders the ability for that startup to really expand and become something big. Is there protections for that small startup business owner, or what is the evolution of the law?
Okay, so I'll paraphrase the question. So the question is whether or not there are, what's the situation for small startup companies and what kind of protections they might have if they're leaving a large company like Google. Okay, so in a state like California, that has a long-standing tradition against non-compete agreements, a company like Google would be limited in what it could say in a non-compete agreement. It cannot, the non-compete agreement cannot be justified by the protection of trade secrecy, so it would have to be some other reason. And so it's pretty limited in that, in being able to say you can't compete. Now, the thing is, that doesn't mean that the startup could go and use trade secrets at a new company. So typically a company like Google, even in a state like California that doesn't enforce non-compete agreements, is going to have a confidentiality agreement with their employees. It spells out what they can and cannot do. Those agreements have to be reasonable. They can't overreach. And also, if there's any invention assignment provision under California law, it's very clear that it has to be something that is within the course and scope of your employment. So if it's outside of that, what you're doing, then you can go ahead and use it. The other thing I'll mention is some companies, and I think Google might be one, they follow an open innovation model. They actually they prefer a model where there's more sharing of information between companies and between employees. And so they're comfortable working in that environment. And I would say generally, I mean, it's probably an overgeneralization, but Silicon Valley is generally comfortable working in more of an open innovation environment than other areas might be. And in fact, some people have attributed the success of Silicon Valley to the fact that they allow employees, and that's, to leave and go do a startup. Yes.
My personal interest is in franchising law, domestic as well as international, and I teach in those areas. I'm interested in your comment about the fact that in certain jurisdictions, there need not be anything in writing, but there may be liability notwithstanding, or in the event of a clear theft of a clear trade secret, there might not be a cause of action. I think that in Illinois currently, there can be a franchise by implication, whether of fact or of law or both, without there being the usual kind of franchise agreement.
Right.
Most franchise agreements that I've looked at have provisions that protect the franchisor's trade secrets from inaction or improper action by a franchisee. And frankly, I have never seen a franchise that existed without that kind of contract, that kind of agreement. And those agreements invariably have protections for the franchisor.
Excuse me.
But you've raised my consciousness about certain states or certain situations in which protection might not be available to a franchisor.
Well, I have some familiarity with franchising law in the United States because when I was in practice, I represented a franchisor. And in California, some states, and I don't know how it is in Illinois, they have, they treat franchise agreements as essentially securities, so they're highly regulated. And so California has a law which says, defines what a franchise agreement is. And so one of the factors is that you're licensing the trademark. So usually what the benefit that the franchisee gets from the deal is largely using the IP of the franchisor, the trademark, the trade dress, and any sort of recipes and so forth. And so, yes, that's why any franchisor is going to be smart and have a trade secret provision in the agreement to prevent them from using it. Now, that type of, that clause would be enforceable in California because, the law, it would allow, it allows that because it's ancillary to another business purpose, and that's really kind of the common law genesis of that non-compete rule. What happened in California is the court was asked to interpret the statute, and because it didn't list trade secrets, they said we're not going to assume, we're not going to read that into the statute. And historically, that's not been read in. But that type of restriction you're talking about with the franchise would be enforceable because it's ancillary to another business purpose, if that makes sense. It's the type of non-compete agreement where you don't have that connection. Another example is the sale of a business. is all, you can have a non-compete agreement with respect to that.
Other questions? Yes.
I wanted to go back to some of your fundamental introductory material and ask you, when you were talking about the increased importance of trade secrets, one of the things that a lot of the blogs took up after the AIA passed and then subsequently after the Alice decision and Section 101 patent eligibility issues arose was that companies now are going to be pushed to use trade secrets much more and to question whether they want to continue to use patents where they may have used them before. Do you have an opinion on this?
I do. I have a draft article I haven't been able to finish, but there's a debate about the changes that were wrought to Section 102 of the Patent Act because of the AIA. And one camp basically says, even though the language changed, Congress didn't intend to get rid of all this law that had to do with, public disclosures that preclude patenting. Another camp, which has been criticized for being a post hoc kind of argument or an after-the-fact legislative history argument, is that no, they intended to change it, and and one of the consequences of the change to 102 is to make it easier for companies to both, to use trade secrets commercially, and then later patent them. Not give up their patent rights because they used it commercially, but secretly. The gist of my article is that may have been the hidden purpose of the AIA, but when you start to peel away the layers of the onion, you realize that it wouldn't work for all businesses. It would work for businesses that have secret processes, which the big one that comes to mind is pharma. But the problem, but as people who represent pharmaceutical companies have told me, why would they want that if it's a first to use? A first to apply rule now for patent as opposed to first to invent. There's a they need to apply for patents. If they sit on their trade secrets, somebody else might patent, and then they're going to be out of luck. The problem with that, of course, is that now there's prior user rights. So you can say, well, you still have prior user rights. Anyway, when you analyze it, I think that there are some industries where it will work, and I think the main industry is pharma. But the Section 102 needs to be interpreted for us to figure that out. And there's a big battle about that issue going on.
Do you see any similar thing going on in the European issuance of the directive? Are there patent bases? I know there's a lot of angst about the unitary patent system and the unitary patent court, and I was wondering if you saw any parallels there.
Well, if it's true that there was this overarching strategy to increase the incidence where certain companies could improve to protect trade secrets and not have to get a patent, then obviously it's in their interest to increase trade secrets protection internationally. So I think it's all tied together. But I don't think it benefits all companies. But the other thing I'll say about the EU Trade Secret Directive, I actually like it, and in this book, there's two appendices. One is an analysis of the proposed EU Trade Secret Directive, which apparently is now being talked, is in process again at the EU. It was sitting there waiting for something to happen for over a year. it's an analysis of that directive, and then the Appendix 2 is an actual copy of the directive with the council amendments overlaid. But what I like about the directive that we don't have in the United States is and this is of course in keeping with directives, it has a list of explicit exceptions and limitations, which you can find in U.S. trade secret law if you look for them, but it's much more helpful to have them listed. So I think that's a really good thing, and it may be that the whole EU trade secret directive backfires on whoever, because those things will be listed, and then that might become the model for the world, rather than the UTSA.
Yes.
This is my first week in law school, and maybe a dumb question, but
Well, congratulations.
if I become a trade secret attorney, can I practice nationwide or only in the state I'm licensed?
That's a good question. No, I mean, you have to practice law in each state where you're licensed. But trade secret law does not require a special license like doing patent prosecution would. So as long as you could get admitted in whatever state you want to practice in, you can practice trade secret. The reason I say it's a good question is, you know, the truth be told, there's people sitting in Chicago who are talking to people not in Chicago or not in Illinois about trade secret issues, you know. So that's another area that the U.S. needs to fix, in my opinion, so that lawyers can move more freely about the country. But that's not going to probably happen anytime soon in the United States.
Yes.
Professor Sandeen, good to see you again.
Hi.
Hi. At the beginning of your presentation, you talked about the trade secret laws summary in a few of the emerging economies, Brazil, China, India, Mexico. I'm curious about whether there is information on the trade secret law status in the other developing nations, like the least developed nations. Do they have some form of trade secret laws, or it's non-existent?
Yeah, one of the remarkable things, I think, from what we did in the country, all countries have trade secret laws, and they're remarkably similar.
Okay.
And so there are differences, but they are remarkably similar. So my research satisfied me that really the rhetoric about the lack of trade secret enforcement is not a lack of laws on the books in the various countries. It's other reasons. You know, so for instance, in India, the concern really is just the time it takes to get any sort of court to make a decision. You know, and in trade secret cases, preliminary injunctive relief is what's wanted, and it's hard to get in India. So there's an example of, and then in other countries, it's not the lack of a judicial process to get the relief, but it's just a different interpretation of what is required or what is a wrong. And I think that will always happen in different countries. They'll always have a different interpretation based on the facts.
I have a question.
Yeah.
This will be the last time left. So I was intrigued by the history of the development of trade secret law in the United States and in civil law countries, sort of industrial revolution. That makes a lot of sense. I'm wondering if there's any analogous story that's going on today in sort of the information age with this pressure at the federal level to have a national trade secret statute, and then also when you talk about harmonization, to have sort of in trade agreements to have a more harmonized international set of standards for trade secret law. Do you think that is being driven by particular industries, or do you where's this pressure coming from? Is it like the government, the United States
Congress and the executive are the ones driving this, or is it really being driven by particular industries to get this protection that they feel is, warranted for their secrets?
Well, there's a lot of different parts to it, but the rhetoric surrounding it is about cyber espionage and spies. That's the rhetoric. But I always say I'm against trade secret misappropriation, and I don't think companies should be cyber hacking in other companies' databases and stealing stuff. I'm against that. But, and I'm not saying it doesn't happen, it does happen. But most trade secret cases are not that case. The vast majority, I would venture to say at least 90%. Most of them are employee cases. Most of them are the employee leaving a company, going to start their own business. And so I tried to figure out what is really going on. I asked people, and what I could figure out is that what's really going on, the big companies think it's easier to go to federal court. Both to go to federal court to get a judgment that they want and then to enforce it. That's basically it. And when I talk about, well, what about the small company who gets sued in federal court and can't afford to defend themselves and has to capitulate, they don't care about that company. The big companies don't care about that company. That's not them. They can't afford to litigate. So what I'm trying to do in opposing the federal legislation is to point out to Congress how it would adversely impact entrepreneurship in the United States. If we overprotect trade secrets, that is the result. If we limit employee mobility, that is the result. And I think that concern, that risk is greater than the risk of spies, to be perfectly honest. That's my view.
Please join me in thanking Professor Sandeen for that.
Our next talk.